you ever interacted with a chatbot, had a loan application processed, or received a decision online, only to later wonder if it was made by a human or an algorithm? As artificial intelligence becomes a bigger part of our daily lives, one of the most pressing questions for organizations in Australia is, when do you need to tell people that AI is making the decision? Hi, I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is actually my AI avatar presenting from a script that I've personally written and approved. In this video, we'll look at the current disclosure requirements for AI-driven decisions in Australia. While dedicated AI disclosure laws are still developing, existing principles of transparency and administrative decision-making already create obligations for organizations. If your organization uses AI in ways that impact individuals, or where AI is the main interface for users, transparency is not optional, it's expected. Under Australian legal principles, openness is a central requirement. That means people have a right to know when AI is involved in making decisions that affect them, even if disclosure might cause embarrassment or reduce confidence in the system. There are some clear triggers that create disclosure obligations. The first is when AI systems handle personal information in automated decisions or user interactions. In these cases, disclosure is required if the use of that information is consistent with the purpose it was originally collected for, if the individual could reasonably expect that use, or if it's necessary to prevent serious threats to life or health. The second trigger is when AI forms part of public-facing operations or automated decision-making that the community has a legitimate right to know about. This is especially relevant for government agencies or organizations carrying out public functions, where disclosure plays an essential role in supporting both transparency and public trust. When it comes to disclosure, there are three important points to keep in mind. First, limitations. Organizations cannot make disclosure conditional in response to access applications. Commercial confidentiality doesn't automatically override the public's right to transparency about AI systems. Second, best practice. Organizations should be proactive. That means clearly explaining how AI systems are used in decision-making, especially if the use of AI is new or unexpected. Transparency about AI isn't just about compliance, it builds trust. And third, practical implementation. Organizations should create clear disclosure policies for AI systems, keep detailed records of how automated decisions are made, and document how user interactions are handled. These policies should always consider privacy implications alongside transparency requirements. Even though Australia doesn't yet have a dedicated AI disclosure law, existing principles already require openness about AI use when it impacts people. Proactive transparency reduces legal risk and builds public trust in your organization. At Leo Lawyers, we provide expert guidance for businesses navigating AI governance and compliance. If you'd like tailored advice on your AI obligations, you'll find our contact details in the description box. Thanks for watching. See you next time.